Good afternoon, ladies and gentlemen. Welcome to the webinar, Joint Ventures with Other Design Professionals, What You Should Know, a webinar brought to you by AIA Contract Documents. Just a few administrative items before we get started. This webinar is being recorded and the recording will be emailed to you along with a PDF of the PowerPoint slides. You should receive the PowerPoint and recording by the end of the week. And you can also find recordings of all of our webinars on our Learn page. This presentation is protected by U.S. and international copyright laws. And this program is registered for one AIA learning unit. When you registered for the course, you entered your AIA member number. We'll be using that information to report your credit directly to the AIA within 14 business days. So you will receive the credit reflected on your online transcript within a couple of weeks of attending this webinar. I'd like to now turn it over to one of our presenters, Amelia Clark. Amelia?
Thanks, Dusty. Thanks, everybody, for being here. We will have questions at the end through the chat, so if a question pops to mind, please send that into the chat and we will look at them at the end if there's enough time. So first of all, we'd like to acknowledge everybody who works on the Contract Documents Committee, so you know who we are. We are between 30 to 35 volunteers. We are all AIA members. There are also outside legal counsel and all kinds of industry advisors who help. We're scattered all over the United States, and we're always looking for volunteers who are willing to come on board and help us out with these documents. So if you're interested, you can go to our website. And in fact, right now is the open season for that, and your tenure would start in January. So the AIA Contract Documents, we are the standard form of the documents here in the industry for the last 131 years. We do update the documents and we evolve the information in them to reflect changes in our industry. We also look at a lot of case law through that process to make sure that we are addressing any legal issues that may have arisen in the last few years. And there are over 200 agreements and forms covering all manner of things within our industry. We are considered the industry standard. We try very hard to be fair and balanced. We understand all the different aspects of the people who are using the contracts, and our mantra is to put risk where it is best managed. And we try very hard to make sure that happens. The process we use to update these documents, first thing we look at are whether there were any legal decisions since the last update that may affect the way something is worded or put into the document. We also look to the industry for comments, so we are always looking out to contractors and owners for their input on these. We look at the impact that those legal decisions and requests from the industry come in to impact the document. We then draft a document and revise it and send it out to our liaisons for feedback from them. So we are looking to them to give us their opinions on the document. The document then gets finalized and published approximately every 10 years. So in this course, we're going to look at what the specific risks are of doing a joint venture with other design professionals. We're going to look at the standard structure of a joint venture and the contracts, and all looking towards fair and proper relationships and sharing of responsibilities. We're going to evaluate the contractual methods to adequately address each party's exposure to joint and severable liability, and we will talk a lot about that. That is kind of the key to all of this. And then also talk about the managerial and dispute resolution strategies that will allow for a successful joint venture. All of this is covered in the document. So now Donovan will speak on the document itself.
So good afternoon, everyone. My name is Donovan Olive. I'm Assistant General Counsel with HOK. Amy and I had the fortunate opportunity to work on revisions to the C101 1993. It was revised this year or issued actually last year. So it's now the C101-2018. We'll talk in a little bit about what some of the revisions were and the thoughts behind that. But I thought it would be good just to kind of start off by talking about, joint ventures in general and why would anyone enter into a joint venture. I know those of you who have practiced in joint ventures, they add complication. They don't simplify anything. They make delivering a project more complicated. There are really tricky insurance issues, and as Amy mentioned earlier, joint and several liability is a key liability that is needs to be mitigated if you're working in a joint venture. So the Documents Committee actually considered retiring the C103 or the C101, but decided against it. And the main reason they decided against it is that joint ventures are still required. Oftentimes, owners will prefer that there's a joint venture. There's some state governments I know in the U.S. that require joint ventures. They also might be required by statute. So all of us will find ourselves at some point being faced with a decision about whether or not we enter into a joint venture. There are also, beyond the regulatory reasons, there might be just important reasons to joint venture just from a commercial standpoint. A joint venture allows a team to submit the expertise of both the firms that are part of the joint venture, so you can get synergies out of different expertise. And oftentimes, a joint venture will give a local face to a foreign architect. So if an out-of-state architect is practicing, they may joint venture with a local architect to have more of a local presence. So it's still something that is important and is common in the industry. So it's important to know that a joint venture can exist whether or not you have an actual contract in place. It is really governed by the way in which the parties conduct themselves in the delivery of design services. And every state law, more or less, will look at a joint venture in kind of the same way, and they look for certain features to determine whether or not the parties are acting as a joint venture. First of all, they'll look to see if they're undertaking a common purpose, if there's some kind of equality in the determining of the direction of that purpose, a sharing in decisions. Also, what is important is a sharing in profits and losses. So if two firms are working together and they are jointly signing the design contract, they're sharing profits and losses, and they're making decisions, there can be a joint venture without having a written agreement in place. Joint ventures are viewed similarly to general partnerships. The big difference with a joint venture is that it's usually a single purpose enterprise, where a partnership might be for the operation of a business and will undertake many different projects. The joint ventures we're talking about today are really project specific. And of course, we'll come back to this over and over again. Parties who are in a joint venture have joint and several liability. That means that any one party is 100% responsible for the obligations, liabilities, and debts of that joint venture. So when I talk to our staff at HOK, I like to talk about sort of the spectrum of joint ventures. At one end, you might have what we call associations. That's where there might be a common commitment to undertake a design contract. All parties might sign the contract, but there might not be a formal agreement between them. At the other end of the spectrum, you have what's called a corporate joint venture, and that's where two companies come together and set up a third company that will actually enter into the prime agreement. Corporate joint ventures, as you can imagine, an association without any kind of a written agreement provides the least amount of protections to the parties, where a corporate joint venture provides the most amount of protection. The problem is that corporate joint ventures are very difficult to unwind. It takes a long time to kind of get through that process, and so they're not as nimble as perhaps maybe something in between. And so that's what we're talking about today, and that's what the C101 is a contractual joint venture. It's a written agreement that does not create a separate entity, but it does create a framework where the parties can operate as if they are an entity in themselves. So one of the first issues in a design contract is, how are you going to structure that joint venture? One approach might be that architect A and architect B come together and form a joint venture, and then that joint venture, those two architects will sign the design contract with the owner, so they have joint and several liability with the owner, but then they will also each sign the consultant contracts, creating joint and several liability with the consultants. This type of structure is common on big undertakings where might be a large airport or something, where the parties are really kind of bringing resources together as far as personnel and maybe co-locating and working as a single entity. Probably more common that we see out there is a scenario where you'll have architect A and architect B come together, but they have really discrete scopes, discrete responsibilities. One might be a design architect and the other the architect of record. If you're working on a large airport project, you might have a landside architect where you have the airside engineer on the as the other party. And in those scenarios, you'll see that there are really discrete scopes and discrete responsibilities, and those the parties can then hold separate contracts with their own consultants. This is the model that we used for making revisions to the C101-2018 because it's one that we see most often, and also it does not create joint and several liability between the consultants. So what is joint and several liability? As we mentioned, this is the fundamental risk of joint ventures, and that means that any one party is 100% responsible for the liabilities of the joint venture. So the owner or any third party does not need to sue all the parties of that joint venture. They only need to go after one party, and that party then must have some mechanism to recover against the other parties. Actual fault is irrelevant when you're determining in a joint and several liability situation. It's just a matter of who is responsible to the owner.
Okay, so we're going to talk a little bit here about the C101, the 2018 version. A change was made during our decision-making process to make it very clear that this agreement is between two or more design professionals. We want to make it very clear you do not want to use this document if you are joint venturing with a contractor and you are a design professional. That's a very uneven playing field at that point. And with joint and several liability, what that means is if something were to happen to the contractor, you as the architect would still be responsible for delivering that entire project, and you're taking the risk on of the entire construction phase. So we just want to underline that. We will say that 15 more times in this presentation. So it was the first update since 1993. So you know, even without a calculator, you can tell that's more than 10 years. It's a very complicated document, and it has been significantly restructured and reorganized. And it's a starting point for establishing a joint venture relationship. We do highly, highly recommend, if you're getting into a joint venture, that you have your attorneys look at this document and the RFP from the client and any other requirements that would need to be included. And just a reminder, this is not the prime agreement. This is not the design contract. This is the agreement between two or more parties, and it is set up to have more than two parties be in the joint venture. All the joint venture partners would be signing the prime agreement with the client. So major changes. We really defined more closely the powers and responsibilities of the policy board. We looked at the role of the project director, you know, all project manager, lots of different titles there, but this is the person who's doing the day-to-day running of the project, and also the project accountant, also known as the treasurer, who manages the books of the joint venture and does the distribution of funds. So very important to understand how that money flows through there. We simplified all of the tax concerns. There was a time and materials option that really clouds the joint venture if you're going to do a time and materials contract. And also, it is intended that the joint venture not retain any funds. So all monies are distributed to the joint venture partners. Sometimes the small amounts of money are left in the joint venture to cover things like costs for the checking account and other minor things like that. But basically, there are no earnings in the joint venture, so therefore there's no tax requirements. Also went deeply into clarifying the ownership of an intellectual property for the project and how to attribute for professional credit, which tends to be a real touchy situation when you get into a joint venture where rather than an engineer and an architect, whoever you're just doing scopes of work, that you may end up in a project where it has multiple architects and who takes the attribution and professional credit for which piece of the project. So identifying that early. We also clarified the obligations of the consultants. So again, back to that diagram Donovan showed you, they are contracted to the parties, not to the joint venture. We understand how the direction is given to the consultants, and also made sure that we had standard flow down provisions like you would have on any contract with a consultant to make sure that all of the insurance requirements and other obligations flow down. The parties to the joint venture, again, two or more, we are requiring a schedule of services to clarify those scopes of work that each party is responsible for. And I'm not even going to try to say bifurcated indemnification, but
we'll talk about that in a little bit.
Yeah, Donovan will talk about that a little bit. And we went pretty deeply into the dispute resolution committee. So that is a separate group of people that if the joint venture parties, the day-to-day people cannot come to some resolution, there is a dispute resolution clause in there. So here's our drafting principles that we came up with. Intended for design professionals only. It is a project-specific relationship. A joint venture is not meant to be like a partnership where it's off into the future, whatever comes up. It is specific for a project. All parties to the joint venture sign the prime agreement. So again, everybody's liable to the client. It is set up as a lump sum. Again, not time and materials. The parties will retain the consultants. And the JV parties may have different interest percentages in the joint venture. So you may have a 51-49, you may have a 50-50, you might have a 90-10, but that can be identified clearly in the contract. Also, joint venture decisions must be unanimous, and we'll explain a little bit more why that is so important. You don't want to be the 10% partner and be outvoted by the 90% partner, as you are liable for their work also. And the parties will share liability on a comparative fault basis. So those are our drafting principles. So the management of the joint venture. So the policy board manages the joint venture. Each party in the joint venture gets a representative on the board. And again, unanimous decision making. Everybody has to agree. We do not vote based on percentages that each party holds in the joint venture. Each party gets a vote. This is the group that negotiates the prime contract. They are the group that establishes the financial controls. They initiate claims on the joint venture's behalf. They are the group that identifies both the project director and the project accountant, excuse me.
Yeah, the policy board really has primary responsibility for management of the joint venture. That's an important thing to think about, that when you're in a relationship with multiple parties, you need some way to share that decision-making process. And all aspects of the joint venture, whether it's listed here or not, are managed through the policy board.
From there, we look a little bit at the role of the project director. So in most cases, this is an employee of one of the parties, already an employee. It's unusual that it would be another person that would be brought in specific for the project, but it does happen. They are the primary point of contact with the client, dedicated to the project. They oversee the day-to-day performance of the services, and however, they are subject to the decisions and direction of the board, so they are not an independent operator. They provide status reports to the board meeting, and they do not have authority to enter into contracts without board approval.
The board may delegate, and the policy board is like a board of governors. They could delegate authority, and sometimes will do that for small contract amounts, but the main decision for entering into contracts rests with the policy board.
And the project accountant, another key person on the team. Normally, again, one of the parties serves as the project accountant. They are required to maintain all the books and the records. They write reports to the policy board on the financial status of the contract. This could be an outside accountant, but that also, again, goes back to the policy board. You have to make sure that they were in on that decision and helped out. Now, each party is still required to maintain their own records. Okay, so the JV has records of all the funding and information contracts, but each party is also responsible to do that just like you would on any other project. This is not to alleviate you of your individual responsibility to maintain your books.
I'd also add that if you're the joint venture party that is providing the project accountant, it is important that the joint venture accounts are kept separate from your normal accounts. And so it's oftentimes they'll set up a separate bank account, money will come into it separately and go out, so the accounting is kept completely separate.
So dispute resolution. So we have the policy board. We also have the dispute resolution board. So this is an effort to eliminate long drawn-out disputes. Each party gets one representative from their senior management, people who are not involved in the day-to-day running of the joint venture, and they are to come together to resolve any issues that have come up. If that can't be resolved, then disputes go on to mediation and binding dispute resolution, either litigation or arbitration. So termination. This is an important aspect of a joint venture. In so many cases, joint ventures come together to do fairly large projects. They go over an extended period of time and things happen. So there are reasons that you may immediately terminate a party, and those include death or disability that severely limit a party's ability to perform, either parties filing a bankruptcy, liquidation, assignment to a creditor, disbarment or suspension of a license required to perform services, indictment in a criminal proceedings, or other incapacity of a party. So these are kind of egregious things that are fairly black and white if they happen. However, there are also the harder things, which is if a party fails to substantially perform. We've all been there. We all know that if your consultant is not performing, it can be very difficult to prove that. However, you do have to give a 10-day notice to cure, and hopefully that helps out on that. But it's very detrimental to the relationship to have to accuse the other party of not performing. Now, the joint venture may continue to perform after termination of a party. All right, the joint venture does not automatically dissolve. If it is a two-party joint venture and one party cannot perform their work or for other reasons becomes not part of the joint venture, you are still beholden to the client to perform those services. So you can form another joint venture and sign another contract with the owner or proceed on supplying those other services.
So we talked about joint and several liability. The main way to allocate joint and several liability between the parties is through the indemnification provisions. So a common misunderstanding in joint venture relationships is that your joint venture interest is your maximum liability. And that's not the case in a contractual joint venture. What a contractual joint venture does is it first will allocate that liability on a comparative fault basis, meaning that you'll look and see, are the parties 50-50 responsible? Is one 100% responsible, or is it split, 70-30 or something like that? And then the trier of fact will then determine that percentage, and that will become the liability. If it cannot be determined on a comparative fault basis, then it's determined according to the interest of the parties. And the interests of the parties are defined in Section 16 as your split in compensation. So, if you if neither party is responsible, and there are circumstances that occur where neither party is responsible, it's something that it's a liability the joint venture incurs. Then it might be that allocation of fee would be how that liability is split between the parties. So we talked about a bifurcated indemnity. This agreement will provide that. What that means is it treats professional liability different from general liability. And so 12.1 is the professional liability clause, and as you'll notice, it does not have a defense obligation. Liability is determined on a comparative fault basis. Well, this is the introductory clause that talks about how liability is determined on a comparative fault basis, and if not, according to the party's interest. And then you'll go to 12.1.1, which says each party indemnifies the other from claims by third parties to the extent the claim results from the negligent act or omission. As I said before, no defense obligation. And then claims unrelated to professional negligence, each party indemnifies and defends the other party from claims from third parties to the extent caused by the party's act or omission. General liability is broader, and a defense is provided under that insurance, where a defense is not provided under professional liability insurance typically. So that kind of brings us to the issue of insurance. Insurance is a really difficult issue to address within joint ventures. Typical policies will not cover the joint and several liability that is assumed in a joint venture contract. Most professional liabilities policies have what they call a contractual exclusion clause, and that basically means that any liability that is assumed by contract that wouldn't exist in the absence of that contract is excluded from the policy. And so what you need to do is, in addition to talking to your attorneys, you want to make sure that you're talking to your insurance brokers when entering into a joint venture to make sure that your policy does in fact cover the joint and several liability arising out of that. Some policies can be endorsed to cover that. If they are not, then you need to understand, if you find yourself the lone man standing or lone woman standing in a joint venture, you may or may not have insurance coverage. There are also other circumstances that need to be addressed in policies. The C101 specifically requires that any exclusions to joint ventures be removed. So if your policy excludes a joint venture outright. That needs to be removed. But also you need to be aware, and your broker should help you with this, if there's other things that you need to do to put into effect coverage. I know for years at HOK we were required to schedule joint ventures, and that's not something that we do any longer, but you might be required to list them when you renew your insurance, or notify your carrier within a certain amount of time of entering into a joint venture agreement. Just make sure that all of those issues are addressed and all of those conditions to coverage are met as you enter into a joint venture. The other big challenge with a joint venture is, how do you meet the insurance requirements of the prime agreement? You know, a simple way to do it, although it creates other complications in a joint venture scenario, would be to obtain a project-specific policy. That policy would, of course, cover all of the parties providing design services on the project up to a certain limit. There would be deductibles associated with that would have to be allocated. And it creates a challenge between the parties on how that insurance resource is used. So if you're a design architect, or let's say you're doing an airport where you're doing maybe landside and airside development, the early completing design party could exhaust the limits of the policy with a single claim before the later completing design. So you might have a roadway claim that is significant and exhausts the limits of the policy, or exhausts the limits of the policy before you even get to the terminal building. So there's challenges there that you need to keep an eye on. Claims management then becomes a joint activity of the policy board, and just making sure then that your insurance is notified, as well as the project-specific insurance is notified of all claims and kept informed about the progress of those claims. It's very complicated. I'm personally not a big fan of project-specific policies. I think they create a number of headaches, but that's one way that you can do it. Another way that you could do it is to require all parties evidence insurance through their practice policy. And the way that the C101 does is it requires each party to show evidence of the amount required by the prime agreement. So if the prime agreement requires $5 million per claim, and in the aggregate, each party then is required to provide $5 million per claim and in the aggregate. And the reason is, any one party could be 100% responsible for a loss on the project, and so it's important that both parties evidence the full amount required by the prime. So just some closing thoughts to keep in mind with the C101, and then we'll take some comments if you guys have questions. We'll read some of your questions. But the C101 is a very, very basic structure of a joint venture. It's a contractual joint venture. It doesn't create a separate company. It's designed for the typical type of joint ventures that that are appropriate for mid-sized projects. So large, complex projects, it may need to be modified. It contemplates that the parties will have a lump sum fee that will be split and accounted for separately, not on a time and material basis. It could be modified to be a time and material situation, but that is not how it's designed. And then it's, of course, as we mentioned earlier, each party has their own separate consultants. And then, again, we can't say it enough, a joint venture is an extremely complicated relationship. It requires advice from your insurance, tax consultants, and legal experts to make sure that you are covered all of your bases and are entering into a joint venture with risk mitigated. So I think we're going to look at, some additional comments about our additional resources if you're interested in more information about this presentation.
Okay, well, great. Thank you, Donovan and Amy. So now we do have some time for questions. If you'd like to enter any questions into the chat or question feature on the right-hand side, we can answer them. So let's give a minute for any questions to come in for our presenters. Okay, questions have started to come in. Is there a contract for corporate joint ventures?
There is not a contract for corporate joint ventures. Essentially, what you would do to create a corporate joint venture is create articles of incorporation, file them with the Secretary of State, and set up a company. And within the articles of incorporation, you would have bylaws and an operating agreement. And the operating agreement may be structured similar to a joint venture agreement. It'll identify officers, directors, set up a board for managing a good company, but it's going to be, it's going to be strictly a corporation that you're setting up. So you'll want to talk to a good corporate lawyer to help you with that. It's not a contractual relationship.
Okay, our next question is, what are percentages based on? Fee?
Yes, they are. As a matter of fact, that you take the total fee in the prime agreement and how is it allocated according, between each party. If it's 50-50, then your joint venture interest is 50-50. If they're, if it's 70-30, then your joint venture interest is 70-30.
Okay. If a joint venture member decisions are meant to be unanimous, how does a JV member get voted out for substandard performance?
That is where it gets sticky.
It's a tough
Especially
one.
if there are only two members in the joint venture.
Yeah, and yes, yeah, there's many complications. I don't know, Amy, if you want to talk on your experience with that. I think what you have to do is you have to document thoroughly through written correspondence the non-performance of your joint venture party. Also, when we've been in situations where we've had to terminate or reduce the scope of the joint venture party, it usually involved the owner. While the owner's not a party to your agreement, they have a huge interest in how you're delivering the work. And oftentimes owners will prevent you from terminating that party, but you still have the obligation to deliver those services. So the way that you demonstrate it is through the written correspondence showing that you gave notice that the the other party did not cure, and after another notice and a reasonable time and opportunity to cure, that didn't happen, then you move to terminate.
Go ahead.
What is the advantage of a joint venture? Seems very risky given J&S liability.
Yep, and that is exactly right. Joint and severable liability does put you at great risk and exposure. So the advantages of a joint venture are that, well, first of all, if they are required, the other advantages is that you can, again, have that foreign office, maybe from another jurisdiction, who has a specialty that you want to bring in, but you want to appear as a single team to the client, very desirable to the client. But yes, we highly recommend you go into that with eyes wide open, which is what we're doing here, is making you understand that you are at risk for that other entity's work.
Yeah, there's almost no good reason to enter into a joint venture for the sake of a joint venture. I would say it's the only time that you would ever enter into a joint venture is if it's specifically required for that solicitation that you're going after, or there is some kind of competitive advantage in doing so. That you are bringing together two different expertise that jointly are submitting on the project, and you can bolster each other's resume by being joint venture partners. But outside of that, they should be avoided. They're not advised relationships.
Next question is, what are the differences between operating as a joint venture and one design firm hiring another design firm as a subcontractor? Is there an AIA contract for that type of arrangement?
So the difference is that in the joint venture, again, you're both liable for all the work. In a contractor subcontractor agreement, the example we like to use is sometimes when you have a design firm and an architect of record, rather than a joint venture, it's better for the architect of record to hold the prime agreement and subcontract to the design architect, because the architect of record needs to be in the lead, as they are the ones liable for the project in the long run. Again, going back to one of our mantras, put risk where it can be best managed. If the architect of record is going to be liable for the project, they have the risk and the authority on the project. So sure, there's the architect sub-consultant agreement, which I don't have the numbers memorized. Does anybody?
Well, it depends on the size of the project. If you're, typically a B101 would be the prime agreement that the architect would enter into, and then the subcontracting party, the consultant, would enter into a C401.
C401, right.
If it's a large project, you might do the B103, which is designed for large projects, and then, of course, the C401, again, is the consultant agreement that AIA publishes. So it would be just a typical arrangement that you would not need a joint venture agreement to do that.
Okay, next question. Should two sole proprietors joint venture or just treat one or the other as a consultant? Attorneys at $375 plus an hour are double the going rate for architecture rate.
If you can prime and if you can have one as a prime and one as a sub-consultant, or one as a consultant, you're always in a better position. Sole proprietors, again, this is where I think oftentimes we'll fall into what we call the association, where they may sign the prime agreement but not really have a formal relationship between each other. Anytime you guys are being jointly responsible for the obligations in the prime agreement, you need a separate agreement that allocates those liabilities and brings clarity to what those responsibilities are between you. And so even sole proprietors, a C101 or something maybe light, but definitely is something that you would need for that relationship.
What is the main difference between the C101 and the C102?
Good question. We just had a presentation on the C101.
So the C102, the teaming agreement, is meant to be used prior to signing a contract with a client. It's meant to be used sometimes prior to the RFP coming out. And what it is an upfront agreement between two parties about how they are going to split the costs of pursuing the project and their intended division of services and fees once the project is awarded to them. So you do not deliver architectural services or engineering services under a teaming agreement. That is strictly an agreement between two parties to go after a project. It's always a confidential agreement. It is frequently an exclusive agreement. So the parties guarantee to each other, I shouldn't use that word, that they will not go on any other teams. So that is a teaming agreement to be used up front. The joint venture agreement, although it can be used up front before an RFP is signed, it does not actually go into effect until there is a project, meaning the team has won the work and signed the prime agreement with the client.
Yeah, and the other point that Amy was mentioning there, the teaming agreement ends upon signing the agreement with the client, so that It's an informal relationship that establishes exclusivity and confidentiality as you jointly pursue a project. But once you win the project, then you'll enter into other contracts to deliver it. The joint venture agreement could also serve as a teaming agreement, but then it would have a life that would continue on into delivering the project. But it's far too complicated to use only as a teaming agreement. If you were, you would only enter a joint venture agreement prior to submitting a proposal if the solicitation required a joint venture to begin with, or evidence of a joint venture as part of the submission.
Can an MOU stand up in court in lieu of the JV contract?
Well, again, an MOU is a memorandum of understanding. It's another form of a teaming agreement. You often refer to a teaming agreement and MOUs. Those terms are used interchangeably. Every single teaming agreement or MOU that I enter into disclaims that it's a partnership, disclaims agency of one party over the other, meaning that, you know, a party cannot obligate the other party to do anything. And so, it will be able to stand up in court for its purpose, to enforce the exclusivity between the parties and the confidentiality, but it's not going to have the risk-shifting terms that a joint venture will have, such as the indemnity, and it probably isn't addressing insurance, but there's really not any liability that arises out of a teaming agreement that would trigger insurance. I don't know, anything else you want to add on that?
No. I think I'm good.
That's it?
Yep.
Okay. Next question. The design architect AOR relationship seems like a more viable option too. Might be a follow-up comment.
Yeah, I think let's see. Having a design architect and an architect of record, yeah, and I think what you're asking there is, how are those two parties related to one another? As Amy mentioned earlier, the best approach would be to have the architect of record enter into a B101, a prime agreement with the client, and then have the design architect enter into a C401 with the architect of record.
Right, because the architect of record has the big risk.
Yeah.
Because they're signing the documents.
So this is a good, this design architect versus architect of record is one that our professionals at HOK often want to consider joint ventures, even when HOK is the design architect. But we really won't do that. I mean, if we have like 20% of the fee or 15% of the fee, it makes no sense to enter into a joint venture and have 100% of the liability.
Especially when you have no control over the documents.
And you have no control over what's going on the backside. So.
And I can answer the next question. Are there LUs for this seminar? There is one learning unit for this seminar. When you registered for the course, you had opted to enter your AIA member number. We will gather that information and use it to directly report your credit to the AIA, and it should appear on your online transcript in the next 2 weeks. You're also going to be emailed the recording and the PowerPoint from today's presentation. That should arrive by the end of this week, early next week. The slide on your screen right now also shows our AIA Contract Documents Learn page. You can access all of our on-demand webinars. Any webinar we do live is recorded and placed on this page, so you can always visit for continued education. You can also contact docinfo@aiacontracts.org if you have any questions on our content, what a provision means, how to complete a form if we have a particular form. So that is available for you, and also any technical support questions regarding the online service can be directed to Docs Tech Support. I'm going to check one more time to see if there's any additional questions that we haven't answered. It looks like there isn't. I'll give another 10 seconds in case you have a last-minute question. You can enter it now. It looks like there aren't any additional questions, so I want to thank you all for your excellent questions and for participating in today's presentation. I also want to thank our presenters, Donovan and Amy, for their well thought out and presented course. Again, we will be following up with you with recording and PowerPoint. So again, thank you all and have a great afternoon.